object to it. And obviously, they can make reversible error if they make comments about the defendant's failure to testify or something of constitutional scope. So be mindful of that. In terms of trying to convey to you a final argument, I did go through my vast storage facility to pull up an old case. And because Eric said, well, why don't you use a case that you had before? So, all right. So, because I am still just kind of a primitive lawyer, not like my technocratic colleague, Mr. Podolsky over here, who does PowerPoint and other matters, I'm still using pen and paper and primitive man's materials for final argument. Again, it's hard to convey a final argument when you haven't heard the case. But basically, this is the case that I tried a while back. There's a murder case on a third DWI where there was a fatality. The facts behind it is a woman about 50 years old. She had two prior DWIs, neither one involving alcohol. And there were some real peculiarities to the case. It occurred on the Beltway. She was driving her vehicle. She was alone in her SUV. And about 3 or 4 miles before the incident occurred, she was tying up traffic because she was driving all over the freeway, from one beyond drunk, just from the far left lane to the far right lane, then the far left lane to the far right lane, at about 25 miles an hour. It's kind of a peculiar thing to do, just backing up the traffic. Meanwhile, as fate would have it, there was a woman who ran out of gas. Runs out of gas on the Beltway. But what you're supposed to do when you run out of gas on the Beltway is you're supposed to call the deputies or the constables to help you get the gas. Well, her papers were not in order. She was an undocumented individual, so she didn't want to involve the authorities. So she got out of her vehicle, and her car was parked on the far right lane of the Beltway, and then she went down to a U-Totem or 7-Eleven or whatever, and got a gallon of gasoline. And then she was standing at the edge of the Beltway, putting gasoline into the car, when my client comes weaving back and forth over the Beltway. And what happens is the poor woman gets hit by my client in her vehicle. The woman flies up into the air, is about 50 feet away when she falls down, and she's dead. And the client's vehicle just continues, and with my client driving, continues to drive on the Beltway at about 20 to 25 miles an hour for about another 20 miles. Finally, she does pull over, and of course, the police are notified, and they pull her over. And when they pull her over, she's foaming at the mouth, and she's non-responsive. They finally get her out, and they know about the decedent, and they put her through field sobriety test. They do the horizontal gaze nystagmus test, and what do you know? She's got uneven pupils. Now, I know a lot of you have tried DWI cases, and one of the things that the officers always talk about at the get-go is they always check for uneven pupils. Well, I defy any of you. Have any of you, have they ever said, yes, her pupils were uneven? Because I've handled a lot of DWI stuff, and I never ran into it. But in this case, her pupils were uneven. And if you can just imagine, a regular-sized pupil and then a pinpoint pupil on the same face, it's a kind of a striking feature. we took the position that she was suffering from an epileptic fit, because the uneven pupils do indicate you either had a head injury or you've had some kind of mental or brain activity that would cause uneven pupils. So she gets out, and then they give her a blood test, and there's some awkward facts, I grant you. There was soma all over the vehicle, where her medicine had spilled out, and she had a number of different drugs in her system. So there was controversy as to whether or not that would impact on whether she was intoxicated or not. So there was controversy on that. And then later, we were able to keep it out because the local constabulary, in their investigation of the case, didn't bother to check her purse, which had marijuana in it. But it was in her blood, which was awkward for the defense. And at any rate, we fought the case, and I gave a final argument that went something like this. Now, like I say, I just used primitive documentation here to assist me in trying to raise a reasonable doubt. So I try to start off with some kind of theme to the argument. The deputy constable that got my client out of the vehicle, and he conferred with one of his colleagues, and what he said on the DVD was, "What's wrong with this woman?" And so that was the theme that I chose to employ. On the video, ladies and gentlemen of the jury, the central question was asked by the deputy constable on the scene. What is wrong with this woman? And I would submit to you that the evidence is compelling that what was wrong with the woman was that she was suffering from an epileptic fit. And if she was in the state of epilepsy, then she could not do, in an epileptic seizure, then she could not engage in a voluntary act. And if she could not engage in a voluntary act, then she didn't have the requisite mental capacity to commit a crime. That is our argument. And that is the question. What is wrong with this woman? Is it the soma, the marijuana, or is it something else? Is there proof, the two central questions in the case, that the jury, that you agreed to wrestle with through the prism of the Constitution, requiring presumption of innocence, burden of proof on the state, and that proof being beyond a reasonable doubt? Is there proof beyond a reasonable doubt of the defendant's intoxication? Or is there a reasonable doubt that the defendant was suffering from a seizure at the time and therefore incapable of a voluntary act? The scientific evidence. The toxicology reports of the blood test did not establish intoxication. Judge J. Burnett, in his wisdom, ruled that both the state's expert as well as the defense expert could not testify that the evidence showed intoxication. All they could testify as to whether or not it was consistent with intoxication or not, which was later reviewed. Now, the bottom line, though, is that if all you've got is testimony that it was consistent with intoxication, that's insufficient. It's insufficient to be able to prove guilt beyond a reasonable doubt. And by the way, almost in all arguments, the state's evidence is insufficient. I urge you to take notice of that and to bring that out to any jury that you're talking to. Whatever it is that the state has provided, it is insufficient. The question of causation. What caused this terrible tragedy? And it's a kind of a which came first, the chicken or the egg? Was it because Miss Ferguson, the defendant, was careening around the Beltway? Or was it because the poor decedent was engaging in reckless conduct by being on the edge of the Beltway, putting gasoline into her car? Who caused this? Had she just done what you're supposed to do? Because we brought you an expert. We brought you an expert that testified, Randall Dodd, who had been in law enforcement for many years in the traffic with the county, saying that you're not supposed to be putting gasoline in your car at the edge of the Beltway. So you have to take that into consideration in reference to the causation of what caused this accident. We would urge you to take that into consideration, that is a dimension of reasonable doubt in this case. There was evidence of reasonable doubt in regard to the seizure. Immediately prior, or maybe 10 minutes prior to this terrible tragedy where this woman was killed, the defendant went and bought a sandwich at a sandwich shop. We brought you in the proprietor of the sandwich shop, and she said she was fine. She was normal. Now, I would submit to you that she got in her vehicle, and we showed you from the map that it was from the sandwich shop right by the Beltway where she got onto the freeway, or the Beltway, and then 10 minutes later there was this terrible accident, and that 10 minutes before she was in a sandwich shop, and she was perfectly all right as far as the proprietor of the sandwich shop was concerned. So how did she become intoxicated in the interim? Something else happened. And what that something else was an epileptic fit. Now, the client had never been diagnosed previous to this incident with this particular problem. So that was a kind of a weak spot in our case, I must admit. But the erratic driving just appears suddenly out of nowhere. Okay, later with the fabled black box that they now have in cars, which is a misnomer, but it turns out she was driving with both feet on the pedal. One foot on the brake and the other foot on the accelerator. That's not the way a normal person drives. That's the way somebody in an epileptic fit might drive. Then there was the testimony of the bystander witness. There was a bystander witness who saw the accident occur and then followed Miss Ferguson in his vehicle and pulled up beside her. And he was on the phone with 911. And on the phone with 911, he says, this woman is either drunk or having an epileptic fit. Can't make that up, but that's what he said. It looks like she was out of this world, is the way he said. It was either drunk or a seizure. That's what he testified. And this was a total stranger, third party, one of these coveted third-party witnesses that are usually against the defense, but in this particular case was very helpful to our theory of the case. He was the only person who actually got to see her face while immediately during the time she was driving. And he described her as being zombie-like, which is inconsistent with intoxication, I would submit to you, ladies and gentlemen of the jury, and indicative of reasonable doubt. Then there's Deputy Constable White in his documented incident report. His description of Miss Ferguson is consistent with seizure, not intoxication. She was incoherent in his report, foaming at the mouth, shaken, and non-responsive, all consistent with seizure. And this is coming from the deputy constable. This is coming from law enforcement. This is coming from the state of Texas. And then Deputy Constable Sergeant Francis administered the horizontal gaze nystagmus test. And he'd been doing it for about 25 years. And it was kind of the one area that he was not properly woodshed on by the very able assistant district attorney. And so when I asked him, well, she had uneven pupils. He said, well, yeah, she did have uneven pupils. I said, well, how long have you been giving these horizontal gaze nystagmus tests, officer? Well, about 25 years. And he's done hundreds of them. He testified to 300 to 400 tests. And then I asked him how many of them had, the big question, which was one of those kind of dramatic moments that we have sometimes at trial, where he didn't really know exactly how to answer it because he hadn't been instructed as to how to answer it prior to testifying. He was asked, well, how many, and I was fishing at this point. How many other horizontal gaze nystagmus tests have you administered where there was uneven pupils? And it was like a 20-second break at the trial where he was trying to figure out what to say. So finally, he opted to tell the truth. Going in a new direction. He said, well, this is the only one. The only example he could recall. Well, now we're talking reasonable doubt. And there was no nystagmus. He was non-responsive to the light. They were claiming that the soma that was all over the car had something to do with it. I don't know. And so, but we took the position that this was not the way she would have reacted if she'd have been on soma. Although, of course, she did have some soma in her bloodstream.